a consent bond with Caleb Brown to Mr. Williams to sign. And that is one, Your Honor, that based on what the jail is saying, they wanted to take care of Mr. Brown's case first. I sent a consent bond with Caleb Brown to Mr. Williams to sign. And that is one, Your Honor, that based on what the jail is saying, they wanted to take care of Mr. Brown's case first. I sent a consent bond with Caleb Brown to Mr. Williams to sign. And that is one, Your Honor, that based on what the jail is saying, they wanted to take care of Mr. Brown's case first. I sent a consent bond with Caleb Brown to Mr. Williams to sign. And that is one, Your Honor, that based on what the jail is saying, they wanted to. Judge, I think you have to mute.
I'm gonna mute yours.
I'm sorry, that keeps happening. Okay. All right, Attorney Freeman, I heard that you said Attorney Mr. Brown, the jail wanted to handle his case first. For what reason?
They indicated that he was being difficult. And they wanted to go ahead and get him back to wherever he needed to go.
Okay, then let's go ahead and do that one. Did you say it was a consent?
Yes, it's one count of trafficking meth. And I'm waiting for Mr. Williams to send you the bond. Angela, do you have that?
I just sent it.
Okay.
I sent it to you and Judge Brown.
Okay.
Okay. Well, then,
and so we do have someone else in the meeting. Who is Josiah Phelps?
Yes, that is my witness for Mr. Leverett.
Oh, okay. Okay.
So we'll be ready on his as soon as we're finished with this first one.
Okay.
All right, so I'm gonna have to take these one at a time and I'm gonna have to go slow. I apologize up front. So I'm gonna start with Caleb Brown since that's the one the jail is needing.
Yes, Your Honor.
Well, Judge Brown.
Yes, good morning.
When good morning, sir. When I spoke to the attorney, they came up with the consent and they told us we could send him back to the jail since he was being disruptive, and we sent him back over, sir. Did you need him to come back over?
Yeah, nobody should have told you that they should send him back.
Okay. Well, I'll have to get him back over, sir, so we can go to the next case.
Yeah, whoever told you that, please don't do that.
Okay.
Let's.
Well, Judge, before the jail gets him back, do you want to review it first to see if you really need him to come back?
Right. Yeah, let me check it. Okay. So I need just first let me get Ms. Coleman on since we got on a little early. So okay. For the record, this is Clayton County Magistrate Court Superior Bond Hearing Calendar for May 8th, 2020. I'm Judge Richard Brown, sitting by designation as a Superior Court Judge for the purpose of handling Superior Court bonds. Court is called, representing the state on all of these will be Assistant District Attorney Cheryl Freeman. The other attorneys will be identified as their cases are called. The court is first calling the first case of State of Georgia versus Caleb Brown, trafficking and methamphetamines in case 2020 WA 06276, represented by Assistant Public Defender Nelson Rhodes. So Attorney Freeman, you have advised the court that there's consent. Can you give me the quick background on it?
Yes, Your Honor. We had this case on the preliminary hearing calendar this week on Wednesday. This is a case where 47 grams of suspected meth that were packaged for sale were found inside of the motel room of this defendant in the toilet tank. No one else was in the hotel room, and I believe some identifying information of Mr. Brown was found in the room. Mr. Brown does have a history, which is why the recommendation is for 125,000 instead of 100,000, which is what we a lot of times will consent to in a trafficking case. And his history is pretty much drug related. He has from 2019 possession of meth, possession of marijuana, possession of a firearm by a convicted felon, and drug related objects. I believe that case is, well, I know he's assigned to Judge Mason for this current case. In 2013, he had a possession of marijuana. 2016, a possession of marijuana.
That's it. You can stop right there.
Okay.
Let me ask you this. How long has he been in jail?
He has been in since March 30th.
And he went from no bond to 125.
Yes, Your Honor.
And when did what date was the $125 bond set?
I mean, that's what I told Mr. Rose I would consent to.
Okay, from no bond and today
125.
125.
And that's with the GPS and a curfew.
How old is he?
Let's see, date of birth is December 94. So that makes him, what is that? 20.
Okay.
5.
Yeah, 24?
All right, that's fine. Okay, do we know who he's going to be living with?
Yes, Your Honor. He'll be living with his brother in Mableton, Georgia.
I can't hear you.
I'm sorry. Yes, Your Honor. He'll be living with his brother in Mableton, Georgia. And his father is also very close by. His whole family is in Georgia. He hasn't ever resided anywhere else in another state.
Where was he living? Who was he living with when this alleged offense occurred?
He was living with his brother still in Mableton.
They can hear me?
Okay, Attorney Freeman, you said that he has a pending case of drugs that occurred like in the recent past and then got arrested for this while that case was pending?
That case may have been, I think it was already resolved. I think it was in Judge Mason's courtroom, but it was from 2019.
If it was resolved, did he enter a plea or is he on probation?
I'm pulling it up now, Your Honor, to let you know exactly what he pled to, or what his sentence was.
Do we have the brother's name and address, Attorney Rhodes?
Yes, Your Honor.
You don't have to give it to me. I just need to know if you have it, because if I approve it, it will need to be written on the order that he must reside at that address with that brother's name. Brother's name.
And Your Honor, his 2019 case, he got 1 year to serve.
What was the charge?
Possession of a firearm by convicted felon.
There was no allegation of a firearm having been found on this case, was there?
No, Your Honor.
Okay. All right, Attorney Rhodes, what'd you say?
I was just about to say yes. I do not have the brother's name at this point, but I do have the address.
Okay. All right, so And this is consented to by the state.
Yes, Your Honor.
Okay, so I will approve it, but I would need to have the address on there, and I will need to have the brother's name with those conditions that you've indicated.
All right, Angela, can you put that on the bond that you have?
Yes, I'll just, Nelson will just text me the address and I'll put the brother's name on there.
Okay, thank you.
All right, so we'll go forward with that one. And anything else, Attorney Rhodes?
If I were to get the brother's name, would it be the best course to have the jail call him up again right now, or I can schedule a video visit with him independently and we can get the bond set on another day? And
No, I will
submit it?
approve it. I will approve it, as long as you put the brother's address and name on there, and you are confirming that that's a good address and he can stay with his brother.
Okay. Thank you, Your Honor.
All right. Anything else on this case?
No, Your
I
Honor.
think that's all, Your Honor.
All right, so I'll stand by for the paperwork with those conditions, and we'll move to the next case. Thank you. Attorney Freeman.
Thank you, Your Honor. I think.
I'm sorry.
let's see.
Deputy, no, there's no need to bring him back.
I got it. I heard you. Thank you,
All
sir.
right, thank you.
And I think, did we need Ms. Bermudez to interpret on any of them? Kendra,
We
did-
do. Yes,
Right.
for
And to get the interpreter finished.
All right, what's the defendant's name?
Esteban Pedraza Cornejo.
Okay, he's coming up.
Thank you.
I can't see the deputy that clear. What's the deputy's name?
No, sir.
Gaines, Judge. Deputy Gaines.
I got him coming up. Mr. Pedraza.
What's the name again, Attorney Coleman? I mean, Mr. Coleman.
Gaines, Deputy Gaines.
Okay. Got you, got it.
And Judge, if I may, I just want to remind everyone that is hearing, the interpreter is going to have to do it consecutive. So I will
Understand.
ask everyone to pause in order for the interpreter to interpret the proceedings.
Okay, I'll let them know if they're going too fast or saying too much.
Yes, sir.
All right. Oh, there, he's there. Okay.
Yes,
All
sir.
right, let me, and hold on a minute. All right, this is position 26 on the calendar. The court is calling the case of State of Georgia versus Esteban Pedraza.
El caso número 26 en la lista de causas, y el juez llama el caso del estado de Georgia contra Esteban Pedraza.
Represented by attorney Kendra Robbins.
Representado por la abogada Kendra Robinson.
And he's charged with 2 counts of child molestation.
Y se le imputan 2 cargos de abuso sexual infantil.
W 51553.
Los números de órdenes de arresto son el número 2020 CW 51553
And 51554.
y 51554.
This is the defense motion, and so Attorney Robinson, you may proceed.
Esta es la moción de la defensa, o sea que abogada Robinson puede proceder.
Thank you, Judge. Your
Gracias,
Honor,
su señor.
we're before the court this morning to ask that the court set a reasonable bond for Mr. Pedraza's case.
Sus señorías, estamos ante la corte en la mañana de hoy para pedirle que le conceda una fianza razonable en el caso del señor Pedraza.
Mr. Pedraza is from Mexico, but he's been in the U.S. off
El
and
señor
on.
Pedraza es de México, pero ha estado en los Estados Unidos probablemente desde 1986.
He has a wife and he has two young sons that he works and cares for.
Él tiene una esposa y tiene dos hijos pequeños, para los cuales él trabaja y los cuales él cuida.
So he has significant ties to the community because he's been living in Georgia most of the time that he's been in the country.
O sea que él tiene lazos o vínculos a la comunidad porque él ha vivido en Georgia la mayor parte del tiempo que ha estado acá en esta comunidad.
I'm sorry to interrupt.
Your-
What part of Georgia?
The greater Atlanta area, the Atlanta metro area, Judge.
En el área metro de Atlanta.
Go ahead.
Proceda.
I don't believe, based off my understanding, that my client doesn't have an extended criminal history or, to my knowledge, any serious criminal history at all. So I don't believe that he would commit felonies, Judge, if you were inclined to give him a bond.
Yo no creo que mi cliente tiene grandes antecedentes penales o que tiene delitos graves, extensos. O sea que yo no creo que mi cliente está propenso a cometer delitos graves si usted le concede una fianza, su señoría.
As well, Judge, I don't believe that if you were to give him a bond that he would obstruct justice in any way or try and make contact with the victims in the case at all, Judge.
Y también, su señoría, yo no creo que él impediría el trabajo de los oficiales de ninguna forma o que trataría de... Can you repeat the last sentence for the interpreter?
Make any contact whatsoever with the victims.
O de que él se pondría en contacto de alguna forma con las víctimas.
Or any other witness in the case.
O cualquier otro testigo en este caso.
Judge, and likewise, property in the community or any persons in the community, Judge.
Y de la misma forma, su señoría, yo no creo que él sería una amenaza para ninguna propiedad o ninguna persona en la comunidad.
Judge, I know the nature of the charges are very disturbing and I know that they are serious.
Su señoría, yo sé que la naturaleza de los cargos son muy groseros y que son serios.
I'm currently in the process of investigating the case and trying to speak with the witnesses that I'm.
Estoy investigando el caso y de hablar con los testigos con los cuales pueda hablar.
But Judge, at this point, we just asked for a bond that he could make and something that is reasonable. He's willing to even wear an ankle monitor or do whatever other conditions that Your Honor thinks would serve justice during the time while we're fighting this case.
Su señoría sea razonable, él está dispuesto a usar un dispositivo para monitorearlo en el tobillo, o de que él también está dispuesto a recibir cualquier otra condición que usted considere.
This was a case that was in front of Judge Dallas, I believe.
Este fue un caso que estuvo ante la juez Dallas, yo creo que el día 4.
But we waived the preliminary hearing and then we ended up on your calendar. So we're here asking Your Honor for a bond because we couldn't get to that issue.
Causa ante su señoría para pedir una fianza porque no pudimos llegar al asunto.
So before you go,
did.
hold on a minute. I'm going to ask Attorney Freeman to come on, but before you finish, I need to know his age and how long he's been in.
Antes, Judge Brown, can you repeat that for the interpreter? The interpreter couldn't hear.
I'm asking Attorney Robinson, I need to know the client's age and how long has he been in jail?
Okay.
Quiero preguntar por cuánto tiempo, qué edad tiene y por cuánto tiempo ha estado en la cárcel.
Judge, we have only been retained for about 2 weeks, and
I'm sorry to interrupt. I just need to know the answer to those two questions. If you don't know, then Attorney Freeman can let me know.
Su señoría solamente no han retenido por las últimas 2 semanas. Si usted no puede contestar esta pregunta, la abogada Freeman la podría contestar.
Ms. Freeman, could you please?
Mr. Pedraza is 48. His date of birth is November 1971. And he's been in, it appears, since March 27th.
El señor Pedraza tiene 48 años de edad. Él nació en noviembre del 1971 y él ha estado encarcelado desde marzo.
And Attorney Robinson, I need to know what's his address and who does he live with?
Abogada Robinson, yo necesito saber su dirección y con quién vive él.
Judge, he lives, I don't know his address. I'll have to get that for you just based off of the nature of how I've been interacting with him and his family. I can get that to you. But he lives with his wife and his children. Those are only people who live at the address that I'm going to provide the court.
Su señoría, yo no tengo su dirección, pero por las interacciones que he tenido con él, con su esposa, yo le puedo dar su dirección. Y él solamente vive con su esposa y sus 2 hijos.
Let me hear from Attorney Freeman, and if you need something to say something else, Attorney Robinson, you can. Attorney Freeman.
Déjeme escuchar lo que la abogada Freeman tiene que decir y abogada Robinson, si usted quiere decir algo más, también lo puede decir.
This is actually a case where the defendant
Gracias, su señoría. Este es un caso donde el acusado
did a voluntary interview at CCPD
hizo una entrevista voluntaria en el Departamento de Policía del Condado de Clayton
and admitted to touching the victims as a
y se alega.
One of the victims during the time was approximately 8 years old.
Una de las víctimas en ese entonces tenía más o menos unos 8 años de edad.
The other victim was around 7 years old.
Y la otra víctima.
What relation?
That's what I was. The relationship was the defendant's wife used to babysit the children.
La relación era que la esposa del acusado acostumbraba a cuidar a estos niños.
From our report, it appears that the mother
Y según el informe, aparenta como que la mamá
went to the police department in January to report
Fue-
the events.
al departamento de policía en enero a reportar el delito.
Attorney Freeman, I'm sorry to interrupt. Yeah, I don't need any more. If he did a voluntary interview, are you, unless there's something else you feel I need to know, let me stop right there and let Ms. Bermudez interpret.
Abogada Freeman, yo no necesito nada más. Si lo que usted tiene en el informe hay algo más que usted necesite decir.
No, Your Honor, I just wanted you to know that the defendant was arrested on March 27th when he gave his interview.
Y no, su señoría, yo solamente quiero dejarle saber que el acusado fue arrestado el 27 de marzo cuando él hizo la entrevista.
Do you, are you consenting to anything, Attorney Freeman?
What I had indicated to Ms. Robinson, oh, and also he does not have any prior felonies.
Señorita, abogada Freeman, ¿está consintiendo usted algún tipo de fianza? Lo que yo le dije a la señorita Robinson es, además, él no tiene delitos menores como antecedentes penales. Perdón, no tiene delitos graves como antecedentes penales. The interpreter needed to make that correction.
In 2013 and 2019, he had a driving without a license.
En el 2013 y en el 2019, él tuvo un cargo por manejar sin licencia de conducir.
I had indicated to Ms. Robinson
Yo le indiqué a la señorita Robinson
that if the court was inclined to grant a bond,
de que si el juez está dispuesto a concederle una fianza,
that I would ask for at least $75,000 on each count.
de que yo iba a pedir que le concedieran por lo menos 75,000 por cada cargo.
That's all I have, Your Honor.
Y eso es todo lo que tengo, su señoría.
Attorney Robinson.
Judge, and that is basically what me and Ms. Freeman discussed, Judge. And so I guess my last request is that if Your Honor is inclined to set a bond, I know that, but you know, Ms. Freeman, pretty much the 150 sum that it would be, that's what I know she's not willing to go below. So, and I've already had a conversation with my client about that. So if you are so inclined to grant a bond, Judge, I would want it to be lower than that, Judge, but I just know that based off of, you know, the nature of the case and other conversations I've had, that's pretty much where we are without an actual consent.
Y basado en la conversación que yo tuve con la señorita Freeman, ese fue el acuerdo que tuvimos y yo hablé con mi cliente al respecto y yo entiendo que ella no está dispuesta a bajar de ahí, pero si usted lo va a considerar, esa es la cantidad que a mí me gustaría que usted considerara.
All right, since there was no significant risk factors that were mentioned by the state and the fact that he voluntarily did an interview, I will grant $50,000 on each.
Your Honor.
Can you repeat the amount, Your Honor, for the interpreter? The interpreter didn't get that.
$50,000 on each of the 2 counts of child molestation.
Yes, sir. Thank you. Y basado en que no hay otro riesgo nombrado por el Estado y de que él dio la entrevista de manera voluntaria, yo le voy a fijar la fianza a $50,000 por cada uno de los cargos.
The court also considered the fact that he has no prior history.
El juez también considera el hecho de que él no tiene antecedentes penales.
However, the address needs to be on there and the court will not sign off on it unless we get the address and it's included on there in terms of his residence.
Yes, sir.
Sin embargo, la residencia tiene que estar incluida en la fianza y el juez no va a firmar la fianza a menos que la residencia de donde él va a vivir esté incluida o la dirección esté incluida. Sí, su señoría.
That
Good.
concludes the case.
Any
Unless there's
other?
anything else.
You want any other conditions?
whatever the state feels appropriate. Of course, no contact with the
No
minor.
contact.
¿Usted quiere algún otro tipo de condición, lo que el Estado considere apropiado, no tener contacto?
We would ask for no contact as well as a GPS.
Nosotros pedimos que no tenga contacto y también que le pongan la tobillera de monitoreo.
And unless there's anything else, that'll conclude this bond hearing.
A menos que no tengamos nada más, esto concluye esta audiencia de petición para fianza.
Thank you, Your Honor, and I'll get that address. And should I send that address? Should I email you with that address, Judge?
Well, Kendra, what I'm going to do, I'm going to email you this bond, and before you send it back, if you can write it in on the bond form. Because you have to sign. I'm going to.
You said before I send it back.
If you can write the address on the bond form.
Okay, perfect.
Okay.
All right. Thank you, Ms. Bermudez. You can be excused.
You're welcome, Judge. Have a good weekend, everyone.
Thank you.
Thank you, Deja. Thank you, Your Honor.
All right.
Thank you, Cheryl.
Attorney Freeman, what's next?
Well, Your Honor, I will say we do have a witness that's in for Leverett. But I know Your Honor said you had a couple of questions on the Antonio Matthews.
Yeah.
So
Let's
we
do
can
that one next.
get
Let's
Mr.
do
Holloway
Matthews.
and Mr. Wade
Let's
off.
do Matthews next.
Mhm.
All right, Matthew's coming up, Judge.
Thank you.
All right, so you can go to court, take the mask off while you speak, and get that speak.
All right, go on the record for this case. Court is calling the case of State of Georgia versus Antonio Matthews. Charged with one count of criminal damage to property in the second degree felony. And the warrant number is 2019 CW 51441. I understand there's consent that has been agreed to. And let me ask Attorney Freeman to kind of summarize.
Yes, Your Honor. Mr. Matthews, the allegation is a criminal damage to property in the second degree. The allegations that after an argument between he and I think it was an ex-girlfriend, that he shot at her car, and the damage exceeded $500. And so, and this is one where the victim has since indicated that I think she spoke to Mr. Holloway and Mr. Wade that now she's not sure if he was the one that shot at the car, but we came to a consent of the $20,000. He does have a couple of convictions. In 2008, he had a possession of a firearm during a crime, a robbery. The GCIC says adjudicated as a juvenile, as well as in 2008, an ag assault and possession of a weapon during the crime. And that's all we were showing for his history. But given the nature of the case and what the victim is saying, we felt that the $20,000 was appropriate. He currently does not have a bond, but we felt that the $20,000 was appropriate. He's been in since April 3rd. No, I'm sorry, not since April 3rd. The warrant was taken out on April 3rd, 2019. I need to pull up to see how long he's been in, unless Mr. Holloway knows how long he's
That'd be
been
fine. I know it's been recent.
in. Okay.
Okay. Let me ask his age.
His age, let's see, born in 1990, so he is about 30.
All right.
Mhm.
Now, let me ask you about, what was the disposition of the 2008 case?
Well, it says adjudicated as a juvenile. Let me put this GCIC.
And my question is, was he on probation at the time of this incident?
Oh, no, he was not. No, the convictions that we have from 2008. And the one, the ag assault, that was out of Fulton County. And that one, it looks like he had a confinement of 8 years.
Wait a minute,
But
8
he was
years?
not on any type of probation when this incident happened.
So he did 8 years in Fulton County. What was the charge?
This was an ag assault and a possession of a firearm during the commission of a crime.
Okay, all right. Do we know? Okay, disregard that. But so, let's see. So he presently has no bond,
That's correct, Your Honor.
and you are recommending how much?
A total of 20,000. And I think this is also with a stay away and a curfew.
Well, if I can speak to
Hold
the
on, hold on, Counsel. I'll bring you in just a minute.
All right.
All right.
And he's been in since March 27th.
Okay, I reviewed the history. Is it true that he shot her car 14 times?
It's a total of 6 times.
6 times. I don't know where I got 14 from.
Yeah, the warrant has 6 times on it.
All right, then it seems like Attorney Holloway wants to go first. Go ahead, Counsel.
Well, thank you, Judge. With respect to a curfew, I don't know that we had discussed that. I don't know that I necessarily have any strong opposition to it, but I don't think that there's going to be a lot of money to even make. It's going to be hard for them to make a $20,000 bond, even with a bonding company. So if that's something the court's going to consider with the curfew, can we maybe just avoid an ankle monitor due to the cost on that? But now that being said,
I didn't say ankle monitor. I just said curfew. Yeah.
All right. Thank you. I appreciate you clearing that up. This happened, whatever happened between them, and there is a factual dispute, and DA is correct that the alleged victim in the case now doesn't believe it was him, and has we can discuss those factual discrepancies later. I don't think that's really why we're here, but in any event, she has been in communication with us. She tells me she's been in touch with victim witness, but she's also relayed that she's not afraid of this man. They have a child together. They have been working together to benefit that child over the last year since this happened in, I think, the spring of 2019. So it's not a recent event, whatever happened. I think they did have a disagreement at the doorway to her apartment. But since then, she tells me she's had no, and she put this in an email, but anyway, she tells me they've had no disagreements. They're getting along fine, that he provides for the child and things of that nature. So he has strong ties to the community. He's got, he owns a residence. Of course, they have that 2-year-old child, that being the only child he's got. He does suffer from Crohn's disease, which is a serious condition, as the court may be aware, and it requires management by a GI specialist. A lot of the time that he was in custody on the case that was just being discussed, he had some issues with Crohn's and not being able to get treatment. In any event, that's sort of where we are. I don't think that he poses a flight risk, certainly, and I don't think he's a danger or a threat to anybody, as indicated by the at least 1 year's time that's passed with no further difficulties between he and his child's mother. So under the circumstances, we think the $20,000 amount that has been agreed to is reasonable, and we'd ask the court to honor that agreement.
Anything else from you, Attorney Freeman?
No, Your Honor.
Okay. So, upon hearing that case was heard by Judge Dallas on May 4th, and it was 1 count of criminal damage to property, 2nd degree, and Judge Dallas was not inclined to do that. Of course, it triggered in my mind that there was more details that needed to be considered. And the fact that he did 8 years in Fulton County for possession of a firearm, robbery, aggravated assault, possession of weapons, commission of a crime. And even though that's been, he's been out for a couple of years, so alleged now that he took a gun and shot 6 times into this vehicle. And so that is a concern, the fact that he would even be possessing the weapon. I understand the alleged victim is now saying she does not know that he's the real one. So given this format on the video conference and not having her here.
And Judge, I will say this is one of the concerns or that I know Attorney Holloway said that he would be able to provide today. And one of the reasons why I'm still consenting to it is from during the week, Mr. Holloway has sent me different documents from various people in support of Ms. Matthews that he didn't have on the day of the hearing. And that was one of the things that that he had indicated to Judge Dallas, I believe, that that he was going to work to get. And like I said, our office, we have been in communication with the victim. We had difficulty at first. I think Mr. Holloway, I believe, may have given us a number or talked to her to let her know that we were trying to reach her. And so again, given the fact that now the story is kind of changing some, but she has said that she does not have safety concerns. We felt that the $20,000 was appropriate in the case.
And Judge, this is Addison Wade, co-counsel with Mr. Holloway. Good morning, sir, again.
Go ahead.
Also on Monday, there were some concerns about the timeline. I think it's critical to note that this happened in April of 2019. And since that time, they have been co-parenting their 2-year-old child, specifically visitation via a third party with absolutely 0 issues. I think Judge Dallas was concerned about the incident that happened in the past. I think it's important to note this young man was a juvenile at the time. He is currently pursuing a master's degree in social engineering at Georgia State and owns his own residence. And I think there's some potential there. I think that those are critical points that we did not know on Monday. And I think that also Judge Dallas wanted to get some clarity on the victim. Again, the alleged victim has told us repeatedly, and I believe the district attorney's office, that not only is she not afraid of Mr. Matthews, they've actually been co-parenting quite nicely for the past 13 months. And that's what I think Judge Dallas wanted to clear up for today's hearing, sir.
Okay, Attorney Freeman, can you confirm that?
Yes, and that is correct, Your Honor.
Okay, well, I think that's an important point. I think I may have overlooked the fact that it did happen over a year ago, allegedly happened over a year ago.
Yes, in April of 2019.
Okay, okay. So let me go back to Attorney Wade, who just, well, let me go back to the issue of him owning his own residence. But when you say own his own residence, is his name on the title?
That's,
yes, sir.
It is, Judge. He and I spoke yesterday, my client and I did, and he confirmed that, and his wife has also sent me that address. And that's, now I can't tell you that I've personally seen the deed, but everybody confirms that he owns a residence there.
Okay, well, yeah, some layperson's interpretation of who owns it might not be the name on the title.
Well, he's here on video, and if you want to ask him, I guess he could confirm that.
I'm gonna put him under oath, and if he's untruthful, then he could be criminally charged. So do you need to advise him of anything?
No, I think he understands that. I think he's prepared to testify truthfully.
Okay. So, Mr. Matthews, can you hear me?
Yes, sir.
All right. You've heard what's been said. I'm going to place you under oath and ask very specific question regarding the ownership of property. You have a right to remain silent, but you have two attorneys and they advised the court that they had given you permission to speak. Do you wish to answer the court's questions, yes or no?
Yes, sir.
Raise your right hand. Sworn statement you give the court in this matter regarding to a consideration for bond on the case as previously stated in the record. Any statements you give would be the truth, whole truth, and nothing but the truth as it relates to ownership of a residence.
Yes, sir, Your Honor.
You can put your hand down. State your name.
Antonio Matthews.
All right. What's your address?
1946 Browns Mill Road. The ownership, the property is
Hold on. What city? What county?
Atlanta, Georgia. That's southeast.
Is that Fulton County?
Yes, sir. Fulton County.
Okay. And are you the owner of that property?
It's under rent to own. I only have like.
Hold on. Is you okay? Are you leasing the property or are you paying mortgage on the property?
Mortgage on.
Say it again.
Mortgage, sir.
All right. So whose name is the property? Who signed the paperwork on the deed for the property?
Well, it's under a company called Keanu Watson Associates. It's a rent to own program. I own like 4 more payments, but right now my mom is handling everything for me because I didn't know when I was going to get out.
Okay, hold on. That's not my question. I just need to know on the, okay.
It's still
who lives there?
I do, sir. My mom and I.
Okay, thank you. I'll go back to counsel. Seems like somebody wanted to say something. Okay, if not, thank you, Mr. Matthews. All right. All right, Attorney Freeman, I'm gonna need you to indicate on the order for bond. Well, let me ask you, have you seen these other documents to confirm his ties to the community and things about employment or owning stuff and education and all that kind of stuff? Have you seen those documents? You're on mute, Attorney Freeman.
I apologize. Attorney Holloway forwarded me several documents about regarding Mr. Matthews and his ties to the community, and I've had a chance to review those before we started this morning.
Okay.
I don't remember seeing anything about him owning the house, but the ties to the community, I've seen those and reviewed them.
All right, well, I think he explained, I kind of understand where you
okay
with that. What I need you to do, Attorney Freeman, I will approve it, but I would need you to indicate the mitigation, and I need you to indicate on the order for bond itself all those mitigating factors, especially the fact that since the alleged incident, the parties have, the victim and the accused have been communicating and have had contact and have been co-parenting for over a year. And any of those other things that indicate ties to the community.
Yes, sir.
To be quite honest, I really was not inclined to grant this bond, but I think I've heard enough to understand that is not exactly what it sounds like. There are mitigating factors that do deserve some consideration. So I thank both attorneys for doing a good job in bringing that to the court's attention. Needless to say, so Attorney Freeman, you need to please indicate on there that if this is true, and this is another reason why I'm granting it, is that the alleged victim has advised that she is not opposed to bond and that she's not opposed to bond. Is she asking for contact?
That's what I just checked with my victim advocate, because before I had a no contact because she hadn't, I don't know if she had told us that she wanted a no violent contact. And it may be if they're co-parenting, it certainly may be something as it relates to the child, but I'm waiting to hear back from Ms. Brookins now about if she wanted no violent contact.
And as to that issue, Judge, I apologize for interrupting. I just now emailed Ms. Freeman every email, basically all the emails I've gotten from the alleged victim in the case, and she speaks to some of those issues. But in any event, I thought that might help her with the information she needs to put on the order.
Well, what happens is, and I think I indicated this before, we certainly have to have information when our victim advocates contact victims. We have to have that contact with them. And so Ms. Brookins is going to try to verify, but it had been a no contact is what the information that we have from the victim. And if I get something different from Ms. Brookins in the next couple of minutes, I'll change it to a no violent contact. But when she spoke to her, it was a no contact.
All right, so that's what I was gonna say. Whatever the victim indicates, please indicate that on the bond order. Unless there's anything else, that'll complete this hearing.
I think that's it, Your Honor.
And I just told Ms. Freeman if anything needs to change, if she needs to do a new order, she has my express permission to sign my name to anything that she needs, and she can just email me when it's done.
All right, Attorney Wade.
Thank you so much, Your Honor.
Thank you, Judge.
All right, thank you both. Have a good day.
You too, sir.
Stand by for the paperwork. All right, we're prepared to go to the next case. Attorney Freeman, what else you got? I know we have waiting on Leverett and Buchanan. I don't know which one.
If we could do
yes, Your Honor. I think because we have a witness on for Leverett, and then we also have a witness that's on for Jacquez Harris. So I think Leverett was up next.
All right, let's do Leverett.
Leverett.
All right, so for 1 second, let's see. Position 17 on my calendar. Court is calling the case of State of Georgia versus Jaylen T. Leverett, charged with 1 count of aggravated assault in 2019 CW 55126 and kidnapping 55127, represented by Assistant Public Defender Leah Abbasi. All parties have been announced ready to proceed, and it appears that Mr. Leverett is present at the podium in the jail. Attorney, have you all, Attorney Freeman, have you all reached an agreement?
No, this was one, I think Mr. Abbasi filed a motion to reduce bond.
I remember that. I got it.
Right.
Okay, Attorney Abbasi, you may proceed. You've indicated already that it was heard on March 25th, and the bond is presently $300,000, and I had indicated I would consider a reduction with additional information and documentation, and you can go forward this morning. Go ahead.
Thank you, Your Honor. Yes, that is correct. We were before you back in March. Additional information that you requested was something that would reflect his proof of employment as well as enrollment in school. Along with the motion itself for a bond modification, I did include, we couldn't find any check stubs, but I do have in there a letter from his employer about a retirement account planned through the employer. I also have included in there the return of a drug test because he was actually applying for a second job. And after that, I do have correspondence between administrators at Georgia State University. Between one another, when this incident first happened, they began trying to find out what occurred and acknowledged him that he was a student at the Georgia State University Dunwoody campus. So I believe those are the documents Your Honor had requested. Additionally, we had discussed that he would be able to live with his grandfather, Mr. Collie Leverett, at his address in Alabama. Mr. Leverett is on here. He appears on our screen as Hosea Phelps, and I did want him here in your Judge, you had requested getting some more information about the living arrangements and what those would be.
Okay, let's stand by. Let me pull up these documents that I did receive. Let's see. Okay, so the first thing is you have 3 exhibits. So the first exhibit, the first thing I need to state is I have concerns. Someone said they would employ somewhere and you can't get anything that really just plainly and clearly and simply states that they were employed. That's a concern.
I'm sorry, Your Honor. We have been looking for check stubs and paperwork. I can certainly contact the employer if you'd like them to write a letter.
Okay, well, you would think from March 25th up until now, you could get more than this. But I appreciate the effort that was made, but it caused the court to pause and some concern about the accuracy of the statement. And and then this thing about a donor, that doesn't really help me one way or the other. And then the thing from Georgia State, I do see that, and I do feel that is a good document for me to conclude that he was a student. Let me go on to say born in 97. Okay, so let me let you, Attorney Bossett, say anything else you would like to say in response to what I just said, and then after that, I'll hear from the grandfather.
Your Honor, I had asked his mother for what documentation she had. She had provided it to me. And if you'd like, I can contact the employer and get a letter from them, and that would just be, my error in that.
Okay, thank you for that. Now, the grandfather's name. Sir, can you hear me?
Yes, sir.
Your name is?
Carly L. Leverett.
Spell your first name.
C-O-L-L-I-E.
Okay, you've been asked to be on this, at this hearing by Attorney Abbasi on behalf of, I understand, your grandson, Jaylen Leverett. Is that correct?
Yes.
All right, if you don't, unless you object, I'm going to place you under oath. If you'd like to raise your right hand. Swearing a statement, okay. Swearing a statement you give the court in this matter will be the truth, whole truth, and nothing but the truth, so help you God.
Yes.
Thank you. You can put your hand down. State your name again and your relationship to Mr. Leverett.
Carly L. Leverett. He's my grandson.
Please understand that these questions I'm going to ask, you're not charged with anything. You are a witness pretty much to provide some background information for the court to make a final decision regarding bond. But please also understand you may be subject to questioning by the Assistant District Attorney, Cheryl Freeman. You understand?
Yes.
Okay. Where do you live?
State Line, Mississippi.
State Line is the name of a city?
Yes.
Okay.
It's in Alabama, Mississippi, in 2 counties.
That one got by me. I don't think I ever heard that one. State Line, Mississippi. Okay. And how much contact have you had with Mr. Leverett? When I say contact, I mean physical contact, being in your person or with you in the past year?
No contact in the past year.
Okay, what about the past 3 years?
I'm sorry, I'm back. When this incident first happened, he came to my house.
Stop. I need you to stick to my specific questions right now.
Okay.
When's the last time that you had any physical contact with him in your presence or living with you? Has it been a year, more than a year, or approximately how long?
Yes, with them a year ago, yes.
Okay, and what was that contact approximately a year ago? What did that consist of? Him living with or visiting?
It was about 6 months ago. He visited with me for 2 or 3 days.
I see, okay. All right. You are agreeable for him to live with you if a bond is, okay. What do you know about his living situation in the past year?
Living with his mother.
All right, do you understand that the court approves the bond that he will be required to live with you?
Yes.
Do you understand that he'll have certain bond conditions?
Okay, whatever.
And those conditions could possibly be no contact with certain people and possibly a curfew. You understand that?
Yes.
And do you think that you have such a relationship that he would abide by your request and condition?
Yes.
Attorney Freeman, you have any questions of this witness?
I don't have any questions for this witness.
All right, Mr. Leverett, I thank you for taking the time to be on. You can remain on. I might have additional questions before it's over. Let me go back to Attorney Abbasi and see if anything else you want to share.
No, Judge, just that we would be asking for a significant reduction in this case. Currently, his bond is $300,000. He is indigent, so a $300,000 bond leaves him little to no meaningful ability to obtain release. And he's been in since December 3rd, 2019. He did turn himself in at that time. And obviously,
sorry, you said he turned himself in?
He did. He
Okay.
turned himself in.
Okay.
Around when this had happened, his mother's home was shot up, suspected to be retaliation for these allegations against him. He spoke with police and then came and turned himself in. So we would be asking for a significant reduction just with the current state of affairs. There literally is no telling when he would be indicted because we don't have a grand jury. So we are asking for a significant reduction, that it be at least cut in half.
Attorney Freeman.
Yes, Your Honor. The state, in speaking with the family of our victim, the state at this time is not consenting to any reduction in the bond.
All right, thank you. What's on the history?
Pull that up. So, Your Honor, the only thing that I am showing, because it looks like the file it was with one of the investigators, but I do have a certified copy of a conviction this is out of Cobb County, from, looks like, I'm sorry? Oh, looks like from 2016. It is let's say 2 counts of, it says criminal attempt to commit a felony. I'm trying to see what that felony was. And then 1 count of theft by taking. Looks like his sentence was 2 years, served 2 months, and then he got a 1 year probated consecutive to count 1.
And I'm sorry. what I have on his GCIC was that he took it as a first offender and it was sealed and successfully completed.
Okay, so I don't have a copy of a GCIC. I just have certified copies of the conviction. And then, what is this? I think that was the same. Yes, that was just the one conviction is what I'm showing.
Okay, all right, I'm good. Anything else, Attorney Abbasi?
No, Your Honor.
All right, taking everything into consideration, the court will cut the bond in half to $150,000 with appropriate conditions to include being allowed to relocate and live with the grandfather. And we need to get that addressed and with the appropriate conditions.
That address is on the original bond order.
I see. Okay. Court understands that the state is opposed to it, given the fact that he turned himself in and has not very serious prior criminal history and nothing since 2016. And we have his grandfather on the video conference to confirm that Mr. Leverett will be allowed to live with him and that he will take responsibility for making sure that Mr. Leverett, the grandson, abides by the conditions. So Mr. Carly Leverett, the grandfather, please understand, should Mr. Leverett, your grandson, not abide by these conditions, all you have to do is pick up the phone and call his attorney or call the district attorney's office and his bond would be revoked.
Yes, thank you.
So Judge, what is the bond that you stated?
Okay, he has 2 charges, right?
Three.
3, okay. Oh, there they are, okay. I got you. So let's do, let's do 100 on the murder, 25 aggravated assault, 25 on the kidnapping.
Okay.
Any questions, Attorney Abbasi?
No, Your Honor.
All right, Mr. Leverett, thank you for joining, and you can come off the we're going to complete this hearing, so that'll be all we need from you, your assistance, and we thank you for that. And Deputy Gaines, Mr. Leverett can go back, and that'll conclude this hearing.
Thank you, Your Honor.
Wait, hold on a minute, Attorney Freeman, go ahead.
I was just asking Leah, can you send me the grandfather's name and that address so I can put it on the bond?
Sure.
All right, thank you.
Thank you, Mr. Leverett. You can sign off.
All right, that concludes this hearing.
Thank you, Your Honor. May I be excused?
You may, thank you.
Thank you.
All right. I'll stand by for Attorney Freeman to advise me. I think you indicated one other case should be next.
I know the case with Mr. Prothero, he has Jacquez Harris. I think his witness is already logged in. And I know there was also Ms. Reddick also wanted to make an argument regarding her case. I believe she has a CLE.
Okay, which one you want to do? Which one you want to do first?
I will defer to Mr. Prothero first, Your Honor.
Oh, nice.
Thank you, Ms.
That's your own Jacquez Harris.
Yes, Your Honor, that's Jacquez Harris, please.
He's on his way up, Judge.
Thank you very much.
All right, sir.
Let's,
Mr. Harris, you get up here, you're gonna take the back.
okay, he has quite a charges. Let me go ahead and go on the record here. Court is calling the case of State of Georgia versus Jacquez Rydell Harris, represented by Defense Counsel George W. Prothero. This is a motion to reduce bond. So there's quite a few charges here. I think I'm gonna let Attorney Prothero just jump in and summarize where we are and how we got here and what he's asking for.
Thank you, Judge. Good morning. Mr. Harris was arrested on December the 29th. He does have approximately 11 charges, Your Honor. They all stem from the same arrest, Judge. For some reason, the DUI charge appears to have a separate warrant number, but they all stem from the same arrest. Essentially, it's a fleeing and attempting to elude case, Your Honor, and reckless driving. My client, again, has been in custody since December the 29th. He's 27 years old, Your Honor. He's completed up to the 11th grade of education in high school. He has not obtained his GED, but he has been working and employed as a diesel mechanic. He learned those skills on the job, Your Honor. His initial bond was $39,000, Judge. We did agree to a consent bond with Ms. Freeman and the state and reduce that bond down to $30,000, Your Honor. However, Mr. Harris and his family are unable at this time to meet that bond, Your Honor. I do have a witness that's prepared to testify. It is Mr. Harris's fiance, Janae Burke. Ms. Burke and Mr. Harris share a 1-year-old daughter that Mr. Harris is responsible for and has been helping raise and provide for, Your Honor. What we're trying to do today, Judge, is to get Mr. Harris, an OR bond. And the reason I'm asking for an OR bond, Your Honor, is he has a hold from Rockdale County. He's on probation in Rockdale. He has an active hold in Rockdale. I provided some documents to the court this morning, a copy of the tolling order from Rockdale County. His probation in Rockdale has been told, and they're basically waiting on him to get over there so they can address his probation. So we're not asking for a bond today, Judge, or an opportunity for Mr. Harris to actually hit the street, so to speak. We're just trying to get him moved over to Rockdale so we can go ahead and get his case over there started and handled. I'm anticipating there will be some type of revocation on his probation there, Judge. And as you know, currently, there's no sitting grand jury in Clayton County or any of the counties in the state of Georgia. So I don't know when his case here in Clayton County will be indicted. But I do think at least if we can get him into the Rockdale County jail, he can start earning time toward that probation revocation and get that process started. Ms. Harris is prepared, my witness is prepared to testify just to the nature of her relationship with Mr. Harris and the care that he has provided and assisted her in raising their child. And I do believe I submitted a letter to the court that was prepared by Ms. Burke. I think I may have called her Harris a minute ago, but that's Ms. Janae Burke. And if you have a copy of that, she's prepared to also answer any questions or testify as to that letter, Judge.
All right, I've received the letter, and thank you, Ms. Burke, for that. And I don't have any questions, but counsel, if you'd like to ask a question, you can.
Ms. Burke?
Yes.
Would you please raise your right hand? Do you swear the testimony that you're about to give this court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Would you state your name for the record, please?
Janae Burke.
You can put your hand down. Ms. Burke, what is your relationship with the defendant, Jacquez Harris?
That is my fiance.
And how long have you known Mr. Harris?
Over 3 years, about 3 years.
And there's a letter that I've submitted to the court for review. I believe you have a copy of that letter. Is that a letter that you prepared?
Yes.
And would you please state to the court why you believe it would be helpful for you to have Mr. Harris's bond reduced?
It's helpful to have it reduced for the simple fact that I am the only one that's taking care of my child right now. And I do have my disabled father at home taking care of her, but he can't do much due to his recent lower back surgery. So the lower that we can get it, so where I can save up my money, I work at pain management. Can I state how much I get paid, or does?
You can state whatever you feel comfortable.
Okay. I'm getting paid $14 an hour, and it's really hard to save up what bonding companies want, which is $34,000.
Okay.
$3,400, I'm sorry.
And you do understand that if the judge reduces Mr. Harris's bond today or gives him an OR bond, that he would go to Rockdale County first. Do you understand that?
Yes.
Okay.
Yes.
And is your desire to have him go to Rockdale County to resolve that case sooner rather than later? Okay.
Yes. Yes.
And you do understand the prosecutor, Ms. Freeman, may want to ask you some questions.
That's fine. Yes.
Okay. I have no further questions, Judge.
All right, Attorney Freeman, any questions?
I don't have any questions for this witness.
All right. Thank
Judge,
you.
I do believe that Mr. Harris was previously, as a child, diagnosed with ADHD. I've spoken with him at length about the decisions that he made that day that precipitated this fleeing and attempting to elude case. He said his primary concern was that he was just trying to get home to his kids. It's not the best decision making in the world, Your Honor. I'll concede that. But I do believe that I'd like the court to at least take into consideration his ADHD, which has, I believe, resulted in some impulse control issues or quick decision making that I think contributed to this case. I will say that there were no guns involved. It was simply an attempt to try to elude the arrest at the time. That being the case, he has been in jail since December the 29th, Your Honor, so we're approaching 5 months that he's been in jail. His case remains unindicted on felony charges. Again, I'm not asking that the court allow him to actually go back out into the community. While I don't think he'll be a danger to the community, what we're trying to do really procedurally is just get him moved to Rockdale County as quickly as possible.
I got it. Okay, Attorney Freeman.
Thank you, Your Honor. Sure. I explained to Mr. Prothero that and given the pandemic, you know, we don't have a grand jury right now. And I certainly don't want to represent when we are going to have one. But I did explain to Attorney Prothero that the state would not be consenting to or a bond. I know his bond is currently, I believe, $30,000 that Attorney Prothero and I consented to in March, and I did tell him that I would consent to a total of $20,000. He does have a history. Started in 2010, an attempted burglary that was here in Clayton County. It looks like he completed his first offender. 2010, he also had a theft by receiving where he completed the first offender. In 2011, he has a theft by deception. 2011, hit and run. 2013, a BGCSA, and that's out of Rockdale County. He got a 10-year probation sentence. 2014, possession of marijuana with intent to distribute, possession of a firearm by a convicted felon. That was here in Clayton County. He got 2 years to serve. In 2014, he had a theft by receiving. And then in 2014, he had a felony obstruction here in Clayton County where he got 2 years to serve. So given his history, and especially in the current charges now, and I hear Attorney Prothero saying he's ADHD, we have a lot of defendants who have that. I certainly don't think that that's a justification or a reason. In this one, you know, he was also charged with a DUI, and he does have a history of narcotics. And so I certainly do not think that an OR bond is appropriate in this case. And again, but given that, I mean, we do not know when we will be able to convene a grand jury. I did indicate to Attorney Prothero that the lowest I would be willing to consent to is a $20,000. And that certainly would be with whatever conditions that the court would impose. Right now, I don't think we impose any extra conditions, just the no violations of the law.
Let me ask you, what is he charged with now? What's the facts on that?
On this one, it's like on December 29th, and this is a summary that, because the case is ready to be presented to grand jury when we do have a grand jury. And so this is a summary that the ADA has already prepared. December 29th, 2019, officers observed a defendant driving a 2009 Pontiac in the area of Fielder Road with an illegal window tint. They attempted to conduct a traffic stop, and that's when the defendant began to flee. During the pursuit, defendant operated his car at a speed in excess of 35 miles per hour, traveling on Fielder Road in excess of 100 miles per hour. The defendant drove on the wrong side of the road, passed vehicles at the double yellow line zones, and failed to obey traffic light at Fielder Road and Conkle Road. Officers were able to conduct a PIT maneuver to disable the defendant's car. He attempted to flee on foot, and he was apprehended. They determined his license was suspended. When they placed him under arrest, they observed him to have red, bloodshot, and watery eyes. They smelled the odor of alcohol and marijuana coming from his breath and person, as well as coming from his car.
Okay. All right. Well, needless to say, there's no way an OR bond would be on anyone, even just on the facts of this one case, let alone his history, full of past convictions of felonies, to include hit and run, 10 years of probation for violation of drug charge, obstruction. I mean, to be quite honest, you're very fortunate to have this bond as low as it is. I mean, I don't know. Mr. Harris appears to be taking a lot of people's kindness for weakness. But just as soon as he can get past one thing, there's another. So court has no sense of him being remorseful or any inclination to believe that the circumstances beyond his control that has led him to be in this situation. Let me ask about the hold in Rockdale. What is that for that 10-year probation on the drug charge?
Yes, Judge.
Okay. And then to get behind, I mean, he's on probation, has a history, and then possibly be intoxicated and no license and fleeing. I mean, it's unbelievable he has a bond, to be quite honest. And he's fortunate to have a young lady in his life that's in his corner. Hopefully he won't take her kindness for weakness.
Can I say anything, Judge? I'm sorry.
Go ahead.
I just want to say that he has definitely tried to change his life, to turn it around now that our 1-year-old daughter is here.
Well, this happened on December 29th, so I don't know how much he's been trying since. How old is the daughter?
She just turned 1 in February.
Well, I mean, she just turned 1 in February, and so that child was born. I don't know. But you heard what been alleged. So anyway, I hear what you're saying, but his actions speak louder than your words. But go ahead, you can finish.
He was the one take anything that I needed for her. I was living with him, and he took absolutely great care of me and our daughter, and was really trying to get his life in order before he decided to. I didn't know what he was thinking here, but he was really trying to get.
I feel you, and I understand. And I thank you for being there. I hope he thanks you and shows it through action going forward. Bottom line is I wouldn't even inclined to set him the bond that's already been set. But given the fact that the state is not opposed and isn't even willing to go lower, I won't oppose it, since Attorney Freeman, if you do 20, to put mitigation on there, you need to have all the conditions. And but for his baby's mother and his attorney, I wouldn't be going along with this, but they have presented a sincere request and plea on his behalf. So because there's nothing he could say that would lead me to believe that he's sincere, or that anything in the past has been anything but his own decision to only think about himself. With that being said, Attorney Freeman, can you advise Attorney Prothero what needs to be on the order before we conclude? But that will conclude the actual hearing, and any other conversation will be between Attorney Prothero and Attorney Freeman. You can go ahead.
Thank you, Judge.
Thank you. And George, I'll get it written up and send it. I'll send it to you via email.
Yeah, send it to me. I'll sign it and fax it, scan it right back to you.
All righty.
What would be the what is the, as you said, a total of 20?
Yes, Your Honor.
And that's on 11 charges?
Yes.
Judge. Yes.
That's why I say that's unheard of. But anyway, what's the most serious charge?
The
The felony charge is the fleeing, attempting to elude.
the fleeing is the only felony, Judge.
Yeah.
Okay.
Everything else a misdemeanor.
How much is that one right now? Fleeing and attempting to elude.
Judge, let's see. That one is instructions. He has a $16,000 bond, Judge, on the fleeing.
Okay. All right, then I'll let Attorney Freeman use those same percentages to reduce it. Thank you. That'll conclude this hearing.
Thank you, Judge. And once I sign the paperwork that Ms. Freeman's going to send, that concludes my business. May I be excused thereafter, Judge?
You may.
Thank you, Judge Brown. Have a great day.
Take care. Ms. Burke, thank you for joining. Take care.
Thank you. Thank you, you too.
All right. As I see Attorney, okay, Attorney Robinson, are you still on? Do you need something from us?
Yes, sir, I am. I was just waiting for Ms. Freeman to send me that bond form so I can sign it. And I didn't ask you if I could be excused, but after I do that, may I be excused?
You may.
Okay. Thank you.
All right. Okay, what's next?
That will be me, Your Honor.
All right, Attorney Reddick.
Good morning again.
Let's see what you got going on here. Who do you have?
Xavier Pittman, Your Honor.
Pittman.
Oh, I see. All right, let me go on the record. This is position 28 on my calendar. Attorney Pittman, are you with the public defender or are you private?
Yes, Judge, I'm Attorney Reddick. My client is Mr. Pittman. We're not together.
I'm sorry. Okay, but you are with the public defender.
Yes, Your Honor, I'm with the Clayton County Public Defender's Office.
All right, so court is calling the case State of Georgia versus Xavier Pittman. Charge one count of strangulation and warrant 2020 WA 06362 and one count of simple battery 06363. Mr. Pittman is represented by Assistant Public Defender Camille Reddick. And have you all negotiated anything? You and Attorney Frank?
The state has, Your Honor, made a reduction. It's not low enough for my client. I would like the court to hear me on the wonderful things. The Ayala factors, let me start there. The Ayala factors that qualify my client for what we believe would be a reasonable bond.
Okay, so if you would start off by telling me the present bond, the last time it was set, and then go from there. And how old are you?
My client, Your Honor, does not have a bond on the aggravated assault by strangulation. He does have a $3,000 bond on the simple battery and a $3,000 bond on the cruelty to children. I believe that was set just literally from walking in the door.
Let me stop you. I'm sorry to interrupt, but I overlooked and I don't see it on my calendar. Accrued to the children. Is that a charge you have, Attorney Freeman?
Yes, Your Honor.
All right, so let me perfect the record. In addition to the aggravated assault by strangulation 06362, there's also a simple battery 06363, and court has been advised there's a cruelty to the children. Would that be a misdemeanor?
Yes, Your Honor, it's a third degree.
And what is the warrant number on that one?
It is 2020 WA 06364.
All right, 64. So with that amendment to the pending charges, I apologize for interrupting. Attorney Reddick, you may continue.
Your Honor, my client is 28 years old. He was arrested on April 1st, 2020. He has no prior felony history. Initially, when this case was filed, and Ms. Freeman will agree, initially when this case was filed, the victim indicated she had concerns about my client. Since he has been in custody, his parents have moved everything that he belongs out of the joint home that they had. He has relocated to Statesboro, where he was attending school, where he was going to be in school, and he had opened a studio. The young lady has now since said she has no concerns for her safety or anything of that matter. They had been together for approximately 5 years before this, Your Honor. While my client has been in custody in Clayton County, he has been attending counseling sessions and dealing with issues of anger and his mental health. He has no prior felony history whatsoever. This is his first offense, and we are not necessarily admitting to the allegations, but he understands that there are things he could have done differently in this situation. When law enforcement arrived on the scene, he was extremely cooperative. He didn't fight, he didn't argue, he didn't run. He was quite forthright with them. Additionally, Your Honor, prior to this incident, my client was in college at IDC Chicago. He returned to Georgia in 2019 after having been a manager at a major hotel in Las Vegas. He is a coach with the Little League of Peachtree Ridge out in Peachtree. He has a job as an event coordinator. He also does social media marketing. He is returning to finish his college education at Georgia Southern in Statesboro, where he would be moving. So we would ask, Your Honor, in light of the fact that we have no idea when a grand jury will be impaneled to even hear this to return an indictment, we would respectfully, Your Honor, be asking on the aggravated assault that you set a bond of no more than $5,000. You reduce the misdemeanor simple battery to $1,500, which ultimately would merge into the aggravated assault if he was found guilty on that. We would also ask that Your Honor put the misdemeanor cruelty to children at $1,500. So a total bond of no more than $8,000. He is not going to be around this young lady. He is going to Statesboro. He's getting in his classes for the summer. He's moving forward with his studio, and she has been informed that their relationship is no longer a viable option.
How much documentation do you have to back up all these claims?
Well, what would you like, Your Honor? I have information from his parents. It's verbal because I've spoken to him, but it's not written.
No. More than verbal. Do you have anything?
I can get it. I have no problem getting it. I can get it, Your Honor.
College in Chicago, a coach,
okay.
IDC coordinator.
Yes, Your Honor.
All these great things. I mean, I hear so many great things at these hearings, and it's almost like a who's who. But nobody has any documentation. Attorneys need to have that. But let me, before I make a final decision as to whether it needs to be reset for you to get that, let me hear from Attorney Freeman. You're on mute.
I apologize. What I will say is Mr. Pittman we're on his record, we're only showing a possession of marijuana from 2015 in that was under conditional discharge. And this is the case, what I indicated to Ms. Riddick, given the charges that he does not have a bond on aggravated assault, and we were willing to consent to a $30,000 on the ag assault, $1,500 on the simple battery, as well as a $1,500 on the cruelty to children in the third degree. And Ms. Brookins is on and can indicate whether or not what our victim has said.
Okay, before she comes on, let me get a little bit more information. But when she comes on, I'll let you ask her any questions. Let you swear her in and ask any questions. But hold 1 second. Can you give me a little information on the alleged offense for this case?
Yes, I apologize, Your Honor. So this is one where, let's see, the victim's mother called 911 and asked for the police to do a welfare check on her daughter. She indicated that she was texted by Ms. Porter that the defendant was trying to kill her. And when the police arrived, they spoke to the victim. She indicated she and the defendant had gotten into an argument about her coming home late And at that point, he put his hands around her neck and began to choke her to where she couldn't breathe. And she said that she texted her mom about the incident. The police did see multiple scratches and fresh bruising on her neck. And Ms. Porter had indicated that her toddler-age daughter was present to see what happened. And what I was, let's see, Ms. Brookins just texted me and she can tell me what our victim has stated.
Your Honor, I will say that Ms. Freeman did
Hold
represent.
on 1 minute. Let me let Attorney Freeman finish.
Right, and this was on, and I can't recall, Ms. Rick may remember if we've had victim contact with her. But that's, I'm waiting for Ms. Brookins to.
Okay, but while you're waiting, let's go back to Attorney Reddick. What did you want to say?
Your Honor, on 5-3, when we were set for prelim, Ms. Freeman did advise that the law enforcement told her that my client was quite forthright and he was cooperative. He wasn't combative in any way with the incident, and that Ms. Brookins did in fact had spoken to the victim, and the victim indicated her change in posture from initially being concerned to no longer being concerned, and I provided the additional information that she wasn't concerned because my client's family had done what I needed them to do, which is move all of his stuff out, let the landlord know he would not be there, and let them know that the young lady was solely responsible for that property. He was staying away completely from her.
That's correct, Your Honor. And Ms. Brookins did text me because, and I apologize, a lot of times we get a lot of these cases and I certainly don't want the facts to start to become cloudy. But yes, we have been in contact with that victim and she does not have any safety concerns now. The defendant's parents did move all of his belongings out of the house. It's my understanding that he will be residing somewhere else, but the victim does not have those fears for her safety. But there would still be a no contact, but she does not have those safety concerns and is okay with him having a bond because his items, he doesn't have anything else at her home.
Okay, let me ask about this. Attorney Reddick, you've indicated that he has or he will be. Has he relocated to Statesboro?
Yes, Your Honor. He actually opened a studio down there just before this incident happened.
So when you say relocated, he has a residence and an address in Statesboro.
I can get the address of where his studio is.
And
Yes,
that's
Your
not
Honor.
a yes. He has a residence.
Yes, Judge. Yes, Judge.
On the
yes.
record, I just need to get all this clear. He has a residence and is living in Statesboro.
Yes, Your Honor.
Okay, is it a house or apartment?
It is an apartment, Your Honor.
So you'll need to provide that to Attorney Freeman if she doesn't
Yes,
have
Your
it
Honor.
already. And all right. Let me- All right, so Attorney Freeman, is it your bottom line agreement as far as what you would agree to on the bond? I think you said 30 and then 1,500 on the two misdemeanors for a total of 33,000.
That's correct, Your Honor. And the reason is, and so we have gotten, I hate to say it influx, but a lot of aggravated assault by strangulation cases. And typically, and Ms. Reddick and all the public defenders will say, I mean, we're pretty consistent in these cases with the 30,000 being my recommendation on ag assault, especially when the defendant doesn't have a record or you know, of any serious convictions. And a lot of times the attorneys do want to present you know, mitigating factors to get a reduction. And I don't have an objection to that. It's just that they know that given the allegations that typically my recommendation would be a 30,000 on the ag assault.
What did what is your, I'm gonna ask you something, hold 1 second.
Mhm.
Oh, as far as the alleged victim,
Yes,
you said that she's indicated she has no safety concerns.
that is correct. When we first had communications with her, there were concerns, but she has since said, since all of the defendants, things have been moved out, the parents came and moved all this stuff, that she does not have any safety concerns.
Okay. What about what you said? 1 second. Oh, Attorney Reddick indicated that he was cooperative with the police. Can you confirm that?
Let me go through the report. 'Cause I know we had another ag assault where a defendant was very cooperative. Let me see. Yes, he was cooperative. He in fact indicated that he admitted to choking Miss Porter. He said when he realized that he was hurting her, he let her go. And so he was cooperative and did tell the police what he had done.
I see.
Mhm.
Okay. All right. Anything else, Attorney Reddick?
Well, Your Honor, in light of my client's no history and the fact that he recognized almost immediately that his behavior was not appropriate and he's getting counseling in the jail for it, we would just ask Your Honor set a very low, reasonable bond on the aggravated assault so that he can get out, because I don't necessarily want him just languishing while we're waiting on a grand jury.
All right. Understood. Thank you very much. Stand by 1 second. The only arrest he's ever had that you've indicated, I think, was a 2015 possession of marijuana. Is that it?
Yes, Your Honor.
And
Your Honor, I believe that was a misdemeanor.
misdemeanor. And,
Yes, it was a misdemeanor.
Okay.
Where he used conditional discharge.
Okay. So it's under first offender.
The conditional discharge is similar. Yes.
Okay. All right. Okay, I would do a total bond of $10,000,
Okay.
and we'll make it 7,000 on the aggravated assault, 1,500 on the other two.
Okay.
There'll be mitigation, given the fact that the alleged victim is not opposed. There will still be a no contact provision. The other mitigation factor is that he has totally relocated out of the metropolitan area to Statesboro, Georgia, and his address needs to be indicated on that order. Other consideration, he has no prior criminal history, and that he was cooperative during the investigation. Unless there's anything else, that will conclude this hearing.
Thank you, Your Honor. I will get that additional information, Ms. Freeman.
Okay, you can either send it to me or send it to Angela. 'Cause I'm writing it down now. Mhm.
Thank you.
All right, thank you, Attorney Reddick. Take care.
Thank
I
you,
like
Judge.
I like your pictures.
I tried, Judge. I tried.
I'm trying to make out. Only I can see is Obama. But,
Well, I have Obama, Lauryn Hill, and Nina Simone.
okay, all right. I should let you see all the ones I have, but we'll talk about that offline.
Yes, Your Honor.
Okay, thank you.
Thank you, Judge.
All right. All right. Attorney Freeman, I'll give you a minute and you can tell me what's next.
So the case of Mr. Buchanan, I sent that consent bond over to Your Honor that Attorney Edwards and I had signed. And so we were just waiting to make sure you approve that so she could be excused.
Okay, second.
This is Attorney D. Williams. I just have Oscar Sells.
Okay, let me take care of the one that was just mentioned. With Attorney Edwards is what you said on Buchanan. Let's try Buchanan. And then Attorney D. Williams will do yours next. On Buchanan. So let me go on the record here. Position 3 on my calendar. Court is calling the case State of Georgia versus Reuben Buchanan, represented by defense counsel Tessa D. Edwards. Mr. Buchanan has 3 charges. Why these charges are not showing up on my calendar. It's only 2, but I see it on the bond order. The first one is criminal damage to property, first degree, warrant 2019 CW 54009. Criminal damage to property in the second degree, 54010. And aggravated assault, 54008. I'm sorry, they all 3 are on here, my mistake.
Yes, Your Honor.
Okay, now, when the original calendar was called, it was brought to the court's attention that he's been in custody since September. And the request today is to reduce from 75 to 40. Okay, and this is a motion for bond reduction.
Yes, sir.
Attorney Freeman, you have, is it my understanding that you are opposed to the reduction or you agree to the reduction?
No, the agreement is the bond that I sent, Your Honor, with a total of 40,000, no violent contact with Shakira Warren. There would still be a no contact with the other people. There are 3 names listed on the bond.
Okay, I have it. And it's indicating that no violent contact as requested by the alleged victim?
Yes.
Okay.
That's one where actually Ms. Brookins spoke to her this morning to confirm that she wanted a no violent contact.
All right. Is let me, Deputy Gaines, I can't see him, but is he there, Mr. Buchanan? Is he present? Have you all brought him out? Okay, let's stand by for Mr. Buchanan.
Okay.
In the back, sir.
Governor Crowley.
Yes, sir.
How you doing?
I'm good.
He said he was in that group that he got sent back to whoever, we could get him back over.
He was in the group that got back, but we can get him.
Okay, well, let me hear, before you get him, let me hear. I did have a few questions, so let's talk about it. Attorney Freeman, can you give me some background on criminal history and the facts surrounding this case? You're on mute, I'm sorry.
I apologize. This is a case that is ready for grand jury, but again, not knowing when that's going to be. So let me. All right, so this is a summary of it. On September 2019, Clayton County Police responded to a shots fired call. they made contact with Miss Shakira Warren and her children. She stated that the defendant, who was her live-in
Well,
boyfriend,
I'm sorry, they hadn't brought him. I'm sorry, he's already. I keep forgetting. I keep looking over there.
Oh.
Go ahead. Go ahead.
Okay. She advised that her live-in boyfriend had shot at her and then shot at the house and her car. But she said that the defendant came home intoxicated earlier, trying to get the keys to his work vehicle, and she prevented him from taking the keys. And it's alleged that the defendant then texted her daughter and said if she loves her mom, she needed to give him the key. Ms. Warren said that the defendant showed up again and shot at her outside. And when she ran inside the house, he shot at the house. Her children were there. And there was damage to her Ford Focus. That's kind of a summary of what happened in the case. Let me pull up his history. And Judge, I believe I sent that packet over to you as well. So you would have the criminal history and a copy of the warrants?
Yeah, I think I reviewed it, but go ahead, and since I've had so many cases, it jogged my memory.
Okay. So in 2008, there was a DUI. In 2012, a disorderly conduct. Both of those were Clayton County. And looks like in 2014, he had a criminal trespass and a cruelty to children in the 2nd degree. And that was in Clayton County, where he got 3 years probation, and it looks like he used his first offender at that time. In 2019, he had an unauthorized discharge of firearms, as well as a criminal trespass. That was here in Clayton County. And then we have the current case.
Okay. What was the disposition on the 2019 case, unauthorized discharge of firearm, criminal trespass?
He received 20 days confinement, weekends only, and 12 months probation.
Okay, and so does that mean he was on probation when this alleged offense occurred?
Yes, Your Honor.
Okay, so since it was mentioned that Judge Dallas had some concerns about this, that's the reason that caused me to pause and look deeper. But let me hear from Attorney Edwards.
Okay, Your Honor, last Friday it wasn't Judge Dallas. I'm not sure of what the judge name was that had the hearing last week. Her only concern was that Ms. Warren, one of the victims, the mother of his children, had not had any contact with the state. I indicated last Friday that the mother, Ms. Warren, had contacted my office a few times about trying to assist in getting him a bond. And I indicated to her my office was closed, so I couldn't meet with her. But I also indicated to the court that as a practice, I try not to speak to victims in cases before the state talk to the victim in the case, because I don't want the appearance that I'm trying to tell them what to do or what to say or whatever. But she so that was the judge's concern, is that the state had not talked to the victim, and the judge didn't feel comfortable with signing the bond without knowing if the victim was okay with him having a bond or how Ms. Warren felt about that. So they rescheduled to this Friday to give me the opportunity to call Ms. Warren and tell her, if you are interested in having contact with Mr. Buchanan, that she would need to return the call from the prosecutor or sign an affidavit in my office or some type of way. They needed to have conversation with her to hear from her about how she felt about contact or how she felt about the bond. And so I reached out to Ms. Warren, spoke to her. I indicated to Ms. Freeman a couple of days ago that I had spoken to her and that she would be available for the court to speak to today regarding the bond or any questions the court had for her because they were concerned. When we paused during the pretrial, the victim advocate from the prosecutor's office did make contact with Ms. Warren and spoke to her, and she indicated the same thing, that she did wish to have contact with Mr. Buchanan, that they had 2 children. When I spoke to her originally a few days ago, I said that the court was inclined to have no contact with her, but that she probably still would have no contact with the children. And she was adamantly opposed to that. He needs to help me with these children. I need help with the kids. And, you know, we need to have contact. We have children. So she's definitely interested in having contact with him, just no violent, aggravating, or harassing contact.
How old is he?
He is 38.
And what about his living situation?
Your Honor, he was living with Miss Warren at the time, but upon speaking to his mother believes that he would be living back with the mother if he's released. Miss Warren wants him to come home, and I have no idea what Mr. Buchanan's intentions were.
What about the condition of his probation, since he was on probation when this allegedly occurred? Anybody heard anything? Anybody aware of any probation considerations or concerns?
I have not heard anything about a probation concern. I don't believe there's anything pending at this time.
I'm just double checking, Your Honor, to see if so one of the things that I see on the GCIC is he did have a probation violation on September 16th, which was which certainly it looks like it was filed, and then it looks like that he did have a revocation on September 27th. And it appears that it may have been based on this case where he got 120 days, according to the GCIC.
So it probably ran concurrent with the time that he's already serving.
Mm-hmm.
Okay. All right. So Attorney Freeman, I have this bond in front of me.
Yes, Your Honor.
And this is one you consent to based on everything you put on the record. I will tell you.
And I would say the current bond was set on October 22nd.
October 2019?
Yes.
Okay.
I can't make out the ADA who signed it, but it was on October 22nd. It was $75,000.
What conditions, if any, would the state be asking for on this, other than no contact and not violating any laws?
Well, those were the same conditions that were in the previous bond.
Stop.
The only difference is on the previous bond, there was a no contact. Warren wasn't even listed on there for whatever reason, but I wrote on the bond that I consented to a no violent contact as requested by Ms. Warren, and kept the no contact with the 2 names, Unjay Battle and Shamabre Hartsfield.
Somebody sound like they're in a swimming pool back there. Okay. What about the, okay, so whether he's gonna live with his mother,
And I Tessie, do you have the information?
okay, one of the attorneys who's not on, I think.
Kayla,
Attorney-
yeah.
Okay, there we go. All right, go ahead. Attorney Green.
Tessie, do you have the address for where he's going to live, or? So we can.
I mean, I'm not sure. Is it an order of the court that he does not live at that house? Because I believe that is what Ms. Warren wants him to return home with her and the children. His mother indicated that if he could not return home, that he could live with her.
Is the bond condition prohibiting him from making contact with the children?
Well,
No.
one of the, I will say this. So one of the persons on the bond, the Unjay Battle, that's a person I think that lives at the home, who is 18, and that's a no contact.
That may be Ms. Warren's older daughter, because she did indicate that she had a older daughter prior to their marriage. So that might be her daughter. So that might take care of it in and of itself, because I know her child is going to live with her, obviously. But I believe that's Ms. Warren's oldest child.
Right, and if she still lives there, there is a no contact with her.
I understand.
Mm-hmm.
Okay, well, I'm going to say I'm going to go ahead and agree to this, but out of reluctantly and out of an abundance of caution, given the fact that he's not supposed to be possessing any weapons, and given the fact that it's alleged that he was intoxicated earlier that day, and while this case is pending, the court is going to and sounds like they let victims more concerned is about getting help with the children as opposed to her own safety. I'm going to require no contact with the victim. And in order to approve it, I'm on no contact with the victim. If something needs to be put in place to give the court some reliability about his drinking and him possessing weapons while on probation. So court has some concerns. If she wants him to come back to help with the children and something else happens, and we know that he has possibly a drinking problem, then that would be a serious oversight on somebody's part that would come back probably to the judge that signs that.
Your Honor, do you want to impose some frequent alcohol and drug testing while he's out on bond? Random, of course.
Yeah, well, that would be good, but in the meantime, I don't think it should be any contact with the victim, the alleged victim. He needs to do what he needs to do. They've never been married. I don't know if the children have been legitimized, so she's concerned about the helping with the children. Then victim witnesses can advise her of how she can file for child support.
So Judge, do you need me to do a new bond, or are you just going to scratch through the one that we submitted?
Yeah, I think we need to do a new one.
I'm not sure. What are we scratching through, or what are we changing?
I put no violent contact with Ms. Warren, and I think the judge is saying a no contact.
Oh, no contact with Ms. Warren. Okay.
Yeah.
I think that's the first bond you sent me, Cheryl. So I already have that one.
Oh, okay. Okay. Well, just send that one then to me, and then I'll forward that one to Judge Brown.
Okay. Will do.
All right. So before we go, so what other names are going to be on the no contact?
The same ones that are listed on the bond, Judge. Those are the same ones that have been on the initial bond. The Unjay Battle and Shamabre Hartsville. Those are also people in the residence.
Okay. All right.
Your Honor, I want to, for clarification, the children, the minor children that they share together, even though they're not legitimized, if Miss Warren allows Mr. Buchanan to see his children, would it be okay if Mr. Buchanan's mother, who does have a relationship with Miss Warren, go over and pick up the children and facilitate bringing the children back and forth so that Mr. Buchanan can assist with helping with the children that way? He can keep them for a few days at his house.
Yeah, well, I just have some concerns about him with this, with these conditions that the alleged victim was highlighted about him being intoxicated until you can file to modify it. Once we get something to show that he's either whether he's enrolled or have addressed his potential alcohol issue.
Okay.
Because, you know, we're talking about shots being fired while the children are present. I mean, this is just traumatic. So I don't even know to what extent and degree the children may have been affected. But I don't want to risk anything. He needs to show that he's serious about the children. And so you can file a motion to modify after you present some documentation, either that is not needed or that he's gotten some help.
Understood.
Okay, and please let the mother know that the court understands she needs help with the children. We're going to put safety over the safety first. And then we need to make sure too that he's going to stay with his mother. So put that address on there.
Okay.
I don't want him to be saying I didn't have any other place to go, so I went back. All right. Any other questions?
Okay. No, Cheryl, give me a few minutes to contact mom and get her address, and I will add that to the bond that you originally sent.
Okay, and I think I sent you a text too.
Okay.
Okay.
Thank you. May I be excused, Judge?
Yes, ma'am. Thank you. Be safe.
You too.
All right. Bye-bye.
Bye.
So, Judge, I think now, I think Ms. D. Williams had indicated that she had Mr. Sales.
Yes.
I'm sorry, before we go there, let me see what's going to be the breakdown on Buchanan as far as the dollar amount.
On Buchanan, we had, it was 30,000 on the ag assault, 7,000 on the criminal damage in the first degree, and criminal damage in the second degree was 3,000.
All right, let's just keep the 30 on the aggravated assault, and then.
Yeah, I mean that was the breakdown for it to be 40,000.
Oh, I see. I got you. Okay, so it'll remain that. Okay.
Yes.
Then that's fine. Okay, so let me just write that in here. 37 and 3. Okay, Attorney D, we are sorry for the delay. Let's go to your case now. And that's going to be submission number, sorry, what's your last name of your client?
Sales, S-A-L-E-S.
Okay, 1 second, let me pull it up. We have one more after this, is that correct? Is that right? Attorney.
This may be the last one.
This may be last one. Okay.
I think Mr. Prothero may be still on, just waiting. I did forward you the bond that we signed on Jacquez Harris, but I think he can be excused. And I think Mr. Williams has the last case.
Okay. All right. Let me put it on the calendar. This is, court is calling case State of Georgia versus Oscar Williams Sales, represented by Assistant Public Defender Angela D. Williams. Mr. Sales has 3 charges. Carrying concealed weapon, warrant 2020 WA 06218. Possessing firearms, looks like by a convicted felon, 06219. and BGCSA, Violation Georgia Controlled Substance Act 06220. Have you all reached an agreement at all?
Yes, Your Honor. And I think Mr. Williams, I think she forwarded to you. The current bond is a total of 20,000. And we consented to just a 5,000 reduction. So it would be a total of 15 instead of 20.
Okay, Attorney D. Williams, sorry to make you wait so long. I should have heard this a little bit earlier because this was just one I needed to double check as to why Judge Dallas had a concern. Can anybody advise me of that?
She said it was just based on his record. However, his record, he does have quite a few run-ins with the police department, but for the most part, they're misdemeanors.
That's correct, Your Honor. He has one felony on his record from 2008. That was a burglary where he used his first offender. And the other charges were all misdemeanors.
Did they involve weapons?
No. He has several obstructions, criminal trespass, one possession of marijuana, and in 2019 he had an obscene language in 911 call.
So the likelihood for him to commit a felony is really low for this client.
Okay, did he complete his first offender in 2008?
Let me double check for you, Your Honor.
How old is he, Attorney D. Williams?
He's 35 years old.
Who does he live with or will be living
His
with?
girlfriend live together and they have, I believe, he had 5 children with her.
I'm sorry, what's living with who?
His girlfriend.
Okay, go ahead. 5 children.
They live
It
together.
looks like he did complete his first offender.
All right.
They live together in Forest Park. So they live in Clayton County. So for him to show up to court wouldn't be a problem.
Okay, what's the facts on this, Attorney Freeman?
This was a case where he was viewed on a camera at, I think it was a Shell gas station on Old Dixie Road, holding a handgun. And he was found to have cocaine in his pocket. 1 second.
I believe the cocaine was residue. It wasn't like a lot or a packaged amount.
And so the police were dispatched to that Shell gas station in reference to a person who had a gun. And so when they got there, they saw on camera Mr. Sales had a gun on him. And then when they searched him, they found the cocaine in his pocket.
Did they find the gun?
Yes, Your Honor.
And so is this one of the charges firearms is this by a convicted felon or during the commission of a crime? My calendar is cut off. 06219.
It says by convicted felon.
So that means he's been convicted of a felony?
And Judge, I'm looking at his GCIC. It says on the escape, wait, let me go back. It says on the escape, well, that was a misdemeanor. So on his first offender, I will say this. It says First Offender Act sealed as a matter of law. And so it does not say conviction, but he did get looks like a 5-serve-1. He did have a failure to appear on the burglary. Well, wait, that was out of the cab, that failure to appear. But I don't have a conviction for a burglary out of the cab. So he may not have completed the first offender.
All right.
Looking at his GCIC, I can't see where he was convicted of a felony, so that charge might be in question.
Okay. All
So
right.
I'd even ask for a $10,000 bond.
Okay. All right. Let me. I have one more question. 1 second. Oh, when was the last time the bond was set?
When
He
he first,
didn't have a the bond he has. He's just been in since April 9th.
I think it's 29th of March.
Okay, give it. Okay.
Oh,
Give it.
I apologize. You're right.
All right. So he's been in since 29th of March, and does he have a bond now?
He does. His bond now is $20,000. And Judge, what I will say is looking at his GCIC on the same charge with the burglary he had in escape, and the escape has convicted, adjudicated. And so if he didn't complete his first offender, like I said, I would, based on that, it appears that he did not successfully complete the first offender. And then again, this was in Fulton, so I can't pull it up here on my screen.
Okay, all right. So bottom line on that is that unless there is some documentation that's provided, then I'm going to consider that to be a good charge until we can get some documentation otherwise. And understand that Mr. Sales might want to say something, but I'm going to hold off and let his attorney direct him. But let me ask two more questions, then I'll see what each one of you want to say, and I'll make a decision. So it's been in since the 29th, and at that time when he was arrested, he had no bond. Is that correct?
No, he did have a bond. He had a $5,000 on the carrying a concealed weapon, a $10,000 on the possession of a firearm by a convicted felon, and a $5,000 on the BGCSA.
Okay. So he's been in since March 29th. Then first appearance, he was set a $20,000 bond. And so we're here today to reduce it to 15 by 5. Okay.
That's correct, Your Honor.
He does have a job lined up if he is able to make the bond.
Do you have
I don't have I can get, I believe, a letter. It's from Raw Sushi. It's a restaurant in downtown.
Yeah, I don't know how many times I have to say that, but word should be out by now. If you come in front of Judge Brown, just somebody saying something is not going to carry much weight. But and that's on the attorneys to know that and get that. But let's see. I'm going to go ahead and agree to the reduction, given the fact that that felony was back in 2008, and we've been in March, and given the condition about indictment. So I'm gonna go ahead and approve it. The question will be what conditions violate the law, and we need address where he's going to be living. Anything else, Attorney Freeman?
I think that's all, and I guess do you need us to send a new bond with the address? I think Ms. D. Williams, if she has that address, she can put that on the bond and resend it.
Well, no, I can just add it.
Oh, okay. Do you have that, Angela, his address? Okay.
She said, yes, you have it.
Yes, Your Honor, I'll email it to you.
Okay. All right, anything else, Attorney Freeman?
I think that completes that case. And I think the only one that's left is Stephen Horn with Ms. Bumpus.
Freeman, we got Ollie as well. What we don't want to do with Ollie?
Ollie was continued.
Ollie was continued?
Yes, because the prelim had to be continued.
Okay, yes, ma'am. So we have, you can take Ollie. Step over to that door. to get Horn.
What, on the sales, Attorney Freeman, what was
Yes.
the breakdown on the new amount?
3,000 on the carrying a concealed weapon, 10,000 remained on the possession of a firearm, and then 2,000 on the BGCSA. It was a small amount of cocaine.
Okay. All right. One more, Attorney Bumper's case. So let's see. What's the name?
Stephen Horn.
Oh, Horn, okay. So this is most for bond reduction. One charge, let's go on the record. This is State of Georgia versus Stephen Manson Horn. Charged with one count of criminal damage to property in second degree, warrant number 2019 CW 55307. And Mr. Horn is represented by Attorney Kayla Bumpers. And our parties have announced ready to proceed. This motion for bond reduction, Attorney Freeman, have you considered and made a decision as to whether you're in agreement on something?
I did send Ms. Bumpers a recommendation for this one. And so I think right now, the current bond is.
I'm sorry, hold on a minute. Who is Winter Parker? There's noise coming from you. Is that your witness, Attorney Bumpers? She's Attorney Bumpers.
I don't know who Winter Park is.
Okay, we need to identify who that is.
Mm-hmm.
For Stephen Horn.
Okay. So who did you get the invitation? Who did she get the invitation to join?
For Stephen Horn.
That is the victim, but I'm sorry, her name is not Winter Horn. That's just the Zoom name.
I see. So this is the alleged victim, and her name is
Eureka Middlebrooks.
Okay. All right, Ms. Middlebrooks, you're gonna need to go to mute until we get to you because you got a lot of background noise. But thank you
I'm muting.
for joining. All right, so let's proceed on. Attorney Freeman, were you talking?
Yes, just indicating that the current bond is 45,000. And I had indicated to, and that was set on February 20th. And I had indicated to Ms. Bumpers that the lowest I would consent to was a 30,000. And that's because the defendant has an extensive history.
Okay, what's the circumstances surrounding this?
Again, this is another case that is ready to present to a grand jury. It was on the calendar, so it is one of those things that we don't know when we're going to have a grand jury and panel. But on December 9th, 2019, officers responded to the address in reference to a domestic disturbance. Officers spoke with the victim, who stated that her ex-boyfriend, who was the defendant at the time, had dropped off their children they have in common. An argument started. The defendant left, returned with two unknown females in an attempt to fight. The victim stayed inside of her apartment, and she indicated she witnessed the defendant throw a brick through the windshield of her 2013 Chevy Malibu. And the oldest child did confirm also what happened. So it's just that one charge of criminal damage in the second degree.
Okay, and what's the history?
Beginning in, 2007, possession of cocaine, 2008, robbery and ag assault, 2008, an ag assault and false imprisonment, 2009, a felony obstruction, 2010, a theft by receiving. That was, looks like a reduced to a disorderly. 2011, disorderly. 2012, a battery. And I'll say this, Your Honor, it appears that the defendant, from the information I have, is also using an alias, and that name is Michael Pitts. And so on our GCIC, the 2012 battery shows a conviction under Michael Pitts. In 2013, there was a disorderly conduct, and that was under Michael Pitts as well. 2013, there was an ag assault. It appears that it was reduced to a battery. 2014, we have a possession of marijuana and a possession of a firearm by a convicted felon. 2015, we have a theft of services. I'm sorry, theft by shoplifting. 2017, we have another shoplifting. 2017, possession of marijuana. 2017, aggravated assault and possession of marijuana. 2018, an assault. And then we have some open cases where we don't have a dispo. In 2018, a sale of marijuana. 2019, open case, possession of marijuana and possession of cocaine and an escape. And then in 2019, we also have a driver with a suspended license. And on our GCIC, Your Honor, we're showing that the defendant is wanted out of the state of Florida for a failure to appear. And because of that history, what I indicated to Ms. Bumpus that I know he's, the bond, like I said, is currently 45. That under the circumstances, again, I don't know when we will be presenting, but she wanted a chance to make her argument to the court.
Okay, go ahead, Attorney Bumpus.
Good afternoon, Your Honor.
Hello.
We definitely understand that my client does have an extensive criminal history. However, the facts in this case allege only that there was damage to a windshield, and it's just a little concerning to me that this was even charged as a felony when the windshield damage only amounted to $149 allegedly. The victim, I have spoken with the victim, and she provided me receipts showing the amount of damage and the amount that it cost to repair the window, which definitely would not be a felony amount. And we are, definitely understanding that there is a criminal history, so we do understand why the bond was so high. However, we're just asking the court to consider the amount of the damages and the fact that I think the victim can testify. She is on the phone, on the Zoom call, if you would be inclined to hear. If you would be inclined to hear from her regarding that. I know that Attorney Freeman said that she would be opposed to me speaking about anything other than bond factors, but just for a little background for the facts, I think that are mitigating factors that I think that the court should hear if you are inclined to.
And Judge, I will say that and I indicated Ms. Bumpus that because the information she was giving me was that I guess information on social media. We don't have any of that. When we spoke to Ms. Middlebrooks, and we last spoke to her on May 4th, there was never any information about that the damages were less than what she had indicated before. She did indicate that she would like the charges dropped, but she does not want contact, and stated she was more concerned about the defendant's girlfriend. Because I believe when I read that there was allegations that the defendant returned and had 2 females with him.
What is the, I was gonna ask, drop off the Anyway, go ahead. I'll think of what I was about to say in a minute.
Well, that completes what I have to say.
And Your Honor, may I add something that?
Go ahead.
The damages were, I think, $149 for the windshield and $200 for some additional type of window, but that still is not a felony amount. Also, my victim is on the line, victim witness, she is on the line, and she can testify to this, that she did not see my client actually throw a brick through her window, but that she watched some kind of Ring video from a door camera of a neighbor, and that even in that video, she only sees the girlfriend, wife of my client, not actually him.
But what did she tell the police?
Your Honor, and that was my concern, is that, like I said, we've spoken with the victim actually several times, and the information that Ms. Bumpers is providing is not the information that the victim told us. And so at this time, you know, the state would be opposed to any of that coming in because it is not relevant to the issue of bond. And we last spoke to her on May 4th, and I certainly don't want it to be, you know, a case of our victim feeling as though, you know, she has to say this versus something else, because we do have the information that she told the police. And we have not gotten any additional receipts or anything of that nature to indicate that the charges were as what Ms. Bumpers has indicated.
Yes, I asked.
Hold on. How much are you saying the damage? How much did she indicate the damage was to you?
Your Honor, I have the receipts.
No, hold on, Attorney Freeman. What was the mention by the alleged victim initially as far as the damage?
I'm sorry, Your Honor. I thought you were talking to me. I'm sorry.
I think initially it was, wait, let me find it. Well, initially, I think we just have, and I have to check to see if she sent in a victim impact statement, but I think initially we had what was in the warrant, the $600.
I see. Okay, all right. So go ahead, Attorney Bumpers. What else did you want to say?
Oh, no, and I'm not sure, please correct me if I'm wrong, Attorney Freeman. I believe this was a private citizen's warrant. I'm not sure. I think that she came in and actually filed for this warrant herself. And I believe that she did list the girlfriend and the other third party. I don't know if she had their names correctly or not, but she did list all of them as present because she did not actually see who threw the brick. However, my client's name, of course, she knows because they share a child together.
Okay. All right.
And he's the only one that has been detained or incarcerated because of this. And we're just asking that the court consider all of that. I was not retained at the initial bond or hearing, so I was not able to present this evidence. I was recently retained.
It was not a citizen's warrant.
Okay.
All right. Okay. So the state's position is, due to the seriousness of his criminal history and the facts of this case, and not to mention that he's presently wanted out of the state of Florida for failure to appear. I mean, that's really doesn't put the court in a position to be opposed to the state's recommendation, taking everything in consideration that the state needs to consider. However, I do know that you have taken the time, Attorney Bumpers, to get the alleged victim on. And before I make a final decision, I will see if anything else you want to say or present. Somebody has some background noise going on that we need to make sure we can clear that up so I can hear. But Attorney Bumpers, I'll turn it back over to you to see if anything else you want to say, or if you want to present a witness. Then I'll let Attorney Freeman make a final statement, and then I'll make a decision.
Miss Middlebrook, are you on the line?
She's on mute. Okay, now she's there.
Yes.
Your
Can
Honor,
you
would
hear
you
me?
like me to swear her in?
Okay, so before we go any further, it needs to be noted it's a courtroom setting. We're on video. So it needs to be the alleged victim, and her name is Eureka Middlebrooks is what I wrote down. Ma'am, you need to be made aware that everything that's taking place is being recorded.
Judge, there's some background noise. I don't know where it's coming from,
It's
but
not me.
it's really hard to hear.
Yeah, I think it's Miss
I don't know if
Middlebrooks.
it's either
I think it's Miss Middlebrooks because it doesn't start till she came on.
if it's
But,
Miss Middlebrooks or Miss Bumpers. I don't know, but it's some loud background noise.
Where I'm at is quiet.
Okay.
Okay, let's try it again. See. Okay, so what I was saying to you, Miss Middlebrooks, is you are not being charged with anything. This case involves Mr. Horn, but you are the alleged victim, and you need to be made aware that everything that is being said at this during this hearing is being recorded by a state certified court reporter. And should you make any statements that are inconsistent with some official documents or official statements you've previously given, you could potentially be subject or being considered for criminal charges yourself for giving any false statements or perjury or similar charges, a few of which would be felonies. So you need to be made aware of that. I don't know what you might be asked or what you plan to say. This is a bond hearing. This is not a hearing to determine whether Mr. Horn is guilty of criminal damage or not. But I need to say that to you before you are sworn in and attempt to make any statements. Do you have any questions about what I just explained?
No.
So because of that potential, I do advise you do have a right to really remain silent. You don't have to say anything. If you choose to, out of abundance of caution, you need to speak to an attorney or need to be clear on what the potential consequences could be of your statements, then you could advise the court that you'd rather not make any statements at this time. But if you choose to make some statements, after I've advised you of your right to remain silent. You don't have to say anything. But if you choose to make any statements, please understand that everything is being recorded. And if you say something that could be against your interests or could provide a basis for the court or for the prosecutor to find that you violated a law, then they could file to have criminal charges issued against you. Do you understand that?
Yes.
All right. Do you have any questions about what I just explained?
No.
All right, then I'm gonna let the Bumpers take it from here.
Miss Middlebrooks, can you raise your right hand? Do you swear the testimony you give today will be the truth, the whole truth, and nothing but the truth?
So if I don't want to speak or say anything, I still have to be sworn in?
Oh, if you don't want to speak, that's fine.
No, I don't want to speak.
Okay.
I just want to say one thing though.
No.
The officer asked me.
No.
Ma'am. You can't do it halfway.
Okay.
Do you want to speak? Yes or no?
No.
Okay. All right. All right, Attorney Bumpers, what else you got?
Well,
Okay,
Judge, at this point, before we start, Judge, you can let Ms. Middlebrooks out the meeting.
All right.
You can, let her out. Yeah.
Okay. All right. Go ahead, Attorney Bumpers.
Okay, Your Honor, I have nothing else to say. I just ask that you consider the amount of damages in this case and, how this is charged. I also ask that, you consider the fact that we don't know when he will be indicted and the fact that he is working. He works in construction, which is an essential job, so it's still open and going. His job is holding his position open, and he can return. And he will be able to go back home and help provide for his children. He does not have to have any further violent contact, and I believe that he is also able to find a third party to facilitate any contact between him and the child that him and Ms. Middlebrook share. And I just ask that the court can consider all these things and will reduce his bond, Your Honor, to $20,000.
All right. Anything else, Attorney Freeman?
No, Your Honor. Just that at this point, all we have is Ms. Bumpus indicating what the amount is. Again, Ms. Middlebrooks hasn't given us anything to say that the damages were a little over $100. I don't have that information. And so again, based on the defendant's history, if the court is inclined to reduce it, we would ask that the lowest would be 30,000. If not, that it remain the same at the 45,000.
And Your Honor, can I just say one more thing? I have offered to email the receipts that I received from the victim to Attorney Freeman, and I can show them to the court if the court would like to see them. But that's just if you would like to see the receipts that the victim sent me.
No need to, but thank you for offering. Attorney Freeman, what is the state's position as far as the last thing that the alleged victim has communicated about bond or not?
I'm sorry, Your Honor.
What is the Ms. Middlebrook's position on bond?
Well, she indicated to us that she would like the charges dropped, but she does not want contact, and that she was more concerned with the defendant's girl. And that's what she told us on May 4th.
I don't know what that is.
I don't know what that is.
Okay. All right. So, the bond presently is at 45.
That's correct, Your Honor.
And he's been in since March 29.
Your Honor, he's been in since February 11th.
This bond was done on February 20th, and at that time, he was represented by the Public Defender's Office.
All right. And the bond is presently how much? 45?
45.
And the state's position is reduce it to how much?
30 is what I had indicated to Ms. Bumpus.
Okay. All right, taking everything in consideration, I'll reduce it to 25.
All right.
Thank you, Your Honor.
Okay, with all the conditions that the state would like to have in there, anything you need to mention on the record, Attorney Freeman, as far as any?
It'll just now. So the bond that the court bond also has in here. Defendant must reside at 1991 Westwood Avenue in Atlanta. Is that still the address he'll be residing?
Attorney Bumpus.
Yes, Your Honor.
Did you hear the address Attorney Freeman gave?
I was looking. Do you mind if I was looking in the messages to verify my phone to verify that's the address that I have?
Okay. And who lives there?
The address that I have is 1993 Bent Creek Way.
Do we know who lives there?
And that's where him and his girlfriend live with their children.
And when you say girlfriend, you talking about the alleged victim or one of the other two females?
One of the other two females.
Okay. So
which address is that the correct address, or is it the one on Westwood Avenue?
Well, that's the address that I have, but my client is on the line.
You want to ask him?
Yeah.
It's the 1991 Westwood Avenue address.
The one that I had?
Yes.
Okay,
All right, and then there'll be no contact with the alleged victim or the minor children. Is that right?
that's correct.
And how many of the minor children, the defendant, the father of any of the minor children that Ms. Middlebrooks is the mother of?
Yes.
Okay, well, he'll have no contact with her nor the minor children while this case is pending.
Thank you, Your Honor.
Okay, all right. That'll conclude this case except for the finalization of the paperwork. Thank everybody for their patience and bearing with the court with the technical challenges. Thank you, Ms. Coleman.
And Ms. Bumpus, I'll scan and email this to you.
Okay, thank you so much. And Your Honor, that concludes my business. May I be excused?
You may.
Thank you so much.
All right. All those who have not signed off, I'm getting ready to end this session of court. We thank you, Deputy Gaines, for your assistance.
Yes, sir.
And we're signing off, and everything else I'll handle with Attorney Freeman and Ms. Sleeth off of the video.
All right, sir. You have a good day.
Attorney Rose, you good? Or is that just a picture?
No,
Oh,
it's me.
okay. All right, over now.
Okay, thank you.
Attorney Williams, thank you. Attorney Reddick.
Okay, Judge.
All right, y'all be safe.
All righty.
Bye-bye.